Thank you. Good morning, everyone. Today is Friday, May 5th, and this is the regularly scheduled Private Probation Services Council meeting. My name is Roxana Gamusio. I am the executive director with this program. On the meeting with us is our attorney, Michael Underhill, as well. And so before I proceed, I would like to do roll call vote to make sure that we have a quorum in order to proceed. So if I call your name out, if you could please unmute yourself and let me know that you are here. Judge Teresa Nelson.
Good morning, I am here.
Thank you, Judge. Judge Joel Perry.
I am here.
Thank you, Judge. Judge Jason Hudson.
Yes, ma'am, I'm here. Good morning.
Good morning. Thank you, Judge. Judge Brody Kane. Okay, and Judge Kane might be able to join us later on, but I have him not with us at this moment. Michael Wright.
Here.
Thank you, Michael. And Stacy Kelly was not going to be able to join us, but we have 4 members on the council, so that meets our requirement for quorum in order to proceed. Notice of this meeting was put on for the May 5th, 2023 meeting was added to the board's website on November the 4th of 2022. Additionally, this month's agenda was posted and has been there since Friday, April the 28th. I would like to go ahead and turn this over to Michael Underhill so we can read the statement of necessity before we proceed.
Good morning. This is the regularly scheduled meeting of the Tennessee Private Probation Services Council. Because there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Secretary of State's office. Pursuant to Tennessee Code Annotated Section 8-44-108, if a physical quorum is not present at the location of the meeting of a governing body, in order for a quorum of members to participate by electronic means, the governing body must make a determination that a necessity exists. Furthermore, Tennessee Code Annotated Section 8-44-108, subsection A, subsection 3 defines necessity as a matter to be considered by the governing body at that meeting, requiring timely action by the body. The physical presence of a quorum of the members is not practical in the period of time required action, and that participation of a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting of the Tennessee Private Probation Services Council, and the necessity of this meeting with members attending by teleconference means is to conduct timely matters of the council that must be discussed and decided prior to the next meeting. All votes will be conducted by roll call. That completes the statement of necessity.
Thank you, Mike. And Judge Kane, thank you so much for joining us. I've got that you're here with us. We just simply read the statement of necessity and the meeting details. If you want to go ahead and turn off your camera, you're welcome to. We've got the recording going on. And so back to the statement of necessity, I would need a motion to accept Mr. Underhill's reading of the statement of necessity.
I so move.
And that is a motion by Judge Kane. Do we have a second?
I'll second it.
And a second by Judge Perry. All those in favor for passing the statement of necessity, please say aye.
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 Thank you. Mike Underhill, because we are virtual, do I need to do roll call vote for the motion?
Yes.
Okay, I apologize. So by roll call vote in agreeing to the statement of necessity that has been motioned and seconded, when I call your name, please go ahead and unmute yourself. Judge Kane?
Aye.
Thank you, sir. Judge Nelson?
Aye.
Thank you, Judge Perry.
Aye.
Thank you, Judge Hudson.
Aye.
Thank you, and Michael Wright.
Aye.
Thank you very much. Next is to accept the agenda. The agenda and all the documents for today's meeting were previously emailed to everyone. If you have any changes to the agenda, we can properly note those now. Otherwise, I would need a motion and a second to accept the agenda as it's been provided and is on our website.
I'll make the motion.
I'll
Thank you.
second.
I believe the motion came from Judge Hudson, and who seconded? I apologize. Judge Perry?
I'll second it, yes.
Thank you. We have a motion by Judge Hudson and a second by Judge Perry to accept the agenda as it's been presented. As I do roll call vote, please unmute yourselves to pass the agenda as it's been presented. Judge Kane?
Aye.
Thank you. Judge Nelson?
Aye.
Judge Perry?
Aye.
Judge Hudson?
Aye.
And Michael Wright.
Aye.
Thank you. And that passes. The next order of business is our meeting minutes from our November meeting. Everyone also received these. If you have any changes that you've noted that need to take place, I welcome those. Otherwise, we would need a motion and a second to finalize the November meeting minutes, and then we post these on the council's website.
I'll make the motion.
Thank you. A motion by Judge Perry. Do we have a second?
I'll second.
Thank you, Judge Nelson. We have a motion and a second by roll call vote. Judge Kane?
Aye, I'm sorry.
That's okay. We understand. Thank you, Judge. Judge Nelson?
Aye.
Judge Perry?
Aye.
Judge Hudson?
Aye.
And Michael Wright.
Aye.
Thank you. That takes care of the minutes itself. Since this is our first meeting for the regularly scheduled meetings for private probation, we need to adhere to Robert's Rules of Order, which of course this council is very familiar with. I would need a motion and a second to conduct ourselves following Robert's Rules of Order. And if we have any questions, Mr. Underhill, I'm sure can assist us.
I'll move that we follow Robert's Rules of Order.
Thank you, Judge Hudson. Do we have a second?
I'll second.
Thank you, Judge Perry. We have a motion and a second to conduct ourselves following Robert's Rules of Order by roll call vote. Judge Kane?
Aye.
Judge Nelson?
Aye.
Judge Perry?
Aye.
Judge Hudson?
Aye.
And Michael Wright.
Aye.
Thank you very much. Quick information for everyone on the council. This is regarding our self-sufficiency hearing. That hearing took place on January 30th of 2023. And the hearing went pretty well. We had some pre-meetings regarding the program not being self-sufficient at different times, and it was determined that we would continue to operate. Obviously, we have a pretty significant amount in the reserves, and so that meeting went well. We didn't have any lingering questions to pass on, but I wanted to share that with the full council. And that leads us, of course, to our director's piece with the budget and the financial information. So that was also sent to everyone. The numbers that we have so far are through February of 2023. So the good thing at this moment is that we do have a surplus for this fiscal year of $11,711. And so we still have several months to go, but definitely the May 20th quarterly provider fee that we'll add. So, I am hopeful that this year we will end with an actual surplus, but that brings our ongoing surplus amount at $602,816. So if there are no questions, this is just that informational piece, but I always welcome any concerns or questions that the council might have. Hearing none, I'm going to turn it over to Michael Underhill to go over the legal report. I believe we have the cases in front of you, and there's a total of 5 or 6 that you've been able to review. So Michael, I will mute myself and turn this over to you for the 6 cases.
Thank you, Roxana. With regard to the 6 cases for the council's consideration, I would like to take one case out of order, that being the last case, item number 6, because the previous 5 cases deal with the same entity. Moving to the back of the line, on case number 6, the summary states, this complaint alleges that probationer was unfairly and illegally violated for attending or leaving a homeless shelter that was not a licensed mental health facility and was not ordered by the court. The respondent states the probationer was discharged from an inpatient treatment center to a homeless shelter because of previous positive drug screens. The probationer could not return home due to drug use in the home, and the probationer sought relocation with family in Kansas to continue her drug treatment plan with the court. The probationer was to remain at the homeless shelter until the court could approve same to leave the state. In the meantime, there was another positive drug screen. Probationer was held until another hearing could be conducted on the violation of probation warrant. The court ordered the probationer to comply with her previous treatment plan, which included reporting to the homeless shelter. The probationer again left the homeless shelter, which constituted another violation of probation, and the probationer was taken into custody without bond. The respondent denies any misuse of power against the probationer. It is important to add, with regard to any allegation that we get with regard to the Private Probation Services Council, they do have to be filtered through the statutes of the Private Probation Council Act as well as the underlying regulations. And with regard to this situation allegation, there is not a situation under the statutes of the regs that where this would fall within the council's authority, whether right or wrong. So I would recommend a vote on closure of this particular complaint.
I would move for closure as well.
Thank you, Judge Kane. We have a motion to agree with legal counsel's recommendation on case number 6. That is by Judge Kane. Do we have a second for that one?
I'll second.
Thank you, Judge Nelson. Voting on case number 6 by roll call vote, Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson,
Aye.
and Michael Wright.
Aye.
Thank you. And Mike, I guess because the others are associated, we can vote on them at the end if that sounds okay with you.
Roxanne, I think due to each case, we may want to vote on those individually since some kind of vary from the others.
Okay, perfect. Thank you.
Moving back to item number 1, this is an anonymous complaint that alleges the following. And again, I'll just read these 8 allegations into the record. Number 1, the respondent probation company was never officially appointed to provide private probation services in the county by the county commission or the mayor. Number 2, respondent owner allegedly was involved in asking for inappropriate favors from female probationers in exchange for not violating their probation for unpaid fees and court costs. Number 3, respondent owner is having male probationers perform personal work for not violating their probation for unpaid fees and court costs. Number 4, the county is owed millions of dollars in court costs and fines that are not collected by the respondent in the course of business. Number 5, respondent owner will not drug test probationers even though law enforcement requests same. Number 6, respondent owner was never legally appointed a probation officer in the county even though the respondent writes violation of probation warrants. Number 7, respondent does not file statutory reports with the criminal court clerk's office. And number 8, since the respondent owner was never properly appointed, the cases filed by the owner are thereby illegal and will subject the state of Tennessee to multi-million-dollar lawsuits. Again, when taking these 8 allegations and filtering them through the statutes of the act as well as the underlying regulations, there are 3 of the 8 that fall within the standards of conduct. That is number 2 about the inappropriate favors with female probationers. Item number 3, having male probationers perform personal work for the respondent. And number 7, the filing of statutory reports with the criminal court clerk's office. An investigation was conducted. Over 100 files were procured from the respondent. Of those files, approximately 2/3 had telephone numbers which I could contact those probationers, and through trying to contact those probationers, I was unable to get any evidence that would substantiate allegations 2 or 3. In addition, for allegation number 7 on the statutory reports, I was able to gather evidence that the respondent had not filed quarterly reports roughly from 2017 to the present day, which is covered by Regulation 1177-01-.05. And so what I am recommending for the council's vote is to send a letter of warning, since this particular respondent does not have a previous disciplinary hearing or prior disciplinary record, to send a letter of warning citing the regulation so that the respondent can become compliant with filing the quarterly reports as well as the underlying information that is required. So that would be the vote on item number 1.
This Judge Kane, did they give a reason why they weren't done for 5 years?
Basically, there was kind of a personal situation that occurred between the respondent and the clerk's office. And so when I spoke with the respondent did try to backfile all of those quarterly reports, but they are to be filed on time and file stamped. He could not provide those to me. So essentially that was the underlying reason.
Okay.
When you say a personal, they couldn't get along, or what was the issue?
Essentially that was it. Yes.
Well, folks, what do y'all think? If we without a history, that's probably an appropriate remedy, but I'd like to know what everybody else thinks.
I'm fine with that. I just, I don't understand personal, animosity, whatever the term would be, keep somebody from filing for 5 years. But if there's no prior history, I'm fine with that also.
Was the personal issue, was that corroborated by the clerk as well?
Yes, it was.
Okay.
Apparently the clerk's office would not accept the filings.
Oh. Huh. Okay.
Why would they not accept the filing?
Because of the underlying personal animosity between the two parties.
So there was an attempt on behalf of the private probation company to file. The clerk just would not accept them.
That is the respondent's assertion. Yes.
Okay. All right.
Did the clerk confirm that?
Essentially, yes, because the best evidence would have been the file stamped copies, and the respondent could not provide those to me.
Was there, and this is kind of off topic, but is there a similar entity to cover the clerk's offices? I mean, I know when I was practicing, I would have the occasional assistant clerk would try to tell me they couldn't take a filing, which always irritated me, is that, they weren't supposed to make that decision. But I'm just curious. I wonder if, is there any kind of oversight for the clerk's offices?
It's my understanding that I think not the clerk itself, but one of the persons working for the clerk's office was the one that was not accepting, but I presume that goes all the way to the top to the clerk.
Yeah.
And have they now, I guess, agreed to accept the filings?
He did try to backfile them, so yes.
So would you prepare the letter, I guess?
I will.
Okay. Any further discussion, folks? All right, Ms. Judge Kane, I would move that that's what we do. I think this is probably appropriate. 5 years is an awfully long time, and I'm not sure. Seems a little weird, the situation we have, but if they've done without any further, any prior issues, I think this is probably appropriate. I would move that we accept legal counsel's recommendation.
I would second that.
Thank you. We have a motion by Judge Kane and a second by Judge Perry on case number 2 to accept legal's recommendation by roll call vote. Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson,
Aye.
and Michael Wright.
Aye.
Thank you, sir. Michael, back to you for number 2, please.
Okay, item number 2, this is an anonymous complaint alleging that the respondent is quote unquote not in compliance with the rules and regulations that govern private probation in Tennessee, close quote. Apart from this being an anonymous complaint and being global in scope, the anonymous complainant did not provide any further specificity or information in support of that. With all due respect, it's kind of hard to investigate a global complaint because basically an inspection or, we'd have to look at every statute and every underlying regulation. And so with respect to this particular item number 2, I would recommend a vote of closure.
I'd make the motion to accept that recommendation.
And I would second it.
Thank you. We have a motion from Judge Perry and a second from Judge Kane to also on number 2, accept legal counsel's recommendation for closure by roll call vote. Judge Kane,
Aye.
thank you. Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson,
Aye.
and Michael Wright.
Aye.
Thank you, sir. Mike, back to you for number 3.
Okay, looking at item number 3, this is an administrative complaint that alleges the following, which is the same allegation in number 7 of the first anonymous complaint regarding the filing of quarterly reports. In addition, the complaint alleges that the respondent is abusing its power by sending a letter to an individual not on probation on company letterhead with the possible intent to benefit the company or an individual associated with the company in accordance with Tennessee Code Annotated Section 16-3-911. I reviewed Tennessee Code Annotated Section 16-3-911, which has the caption public officer or employee of a governing authority and the benefit from contract with a private entity governed by the council. And it applies to contracts between a private entity, which obviously would include the respondent, but also a governing entity, which be a county, a municipality, a metropolitan government, and does not apply to a private citizen, which was the third party that I spoke with regarding this complaint. Essentially, what I'm saying is that this is outside the scope of the council's authority since it does not fall within an explicit statute or an explicit regulation. Since we're already sending a letter of warning regarding allegation number 7 on the quarterly complaints, my recommendation for the vote would be closure since we're already sending that letter out regarding allegation number 7 about the timely forwarding of the quarterly reports. That would be the recommendation.
I move we accept council's recommendation.
I'll second it.
You have a motion from, I believe, Judge Perry. Am I correct?
No, it was me.
I seconded it.
You second it, and Judge Hudson did the first motion. Thank you. I apologize. A motion by Judge Hudson and a second by Judge Perry, and this is on case number 3 by roll call vote. Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson,
Aye.
and Michael Wright.
Aye.
Thank you very much, Mike. We're on number 4, please.
On item number 4, this is an anonymous complaint alleging that the respondent is not filing a violation of probation warrant when the probationer does not pay their costs and fines within 1 year. He provided some documentation of certain cases where that did not occur. However, this allegation is not within the scope of the council's authority. Furthermore, in procuring the files, there were orders from the county court, which essentially, I guess, would be a contract between the judge and the probationer, that covers that all fees and court costs will be paid directly to the clerk. So that takes the respondent out of the situation entirely. So my recommendation for the vote would be closure of this particular complaint, since it is not within the statutory or regulatory authority of this council.
I would move to accept the council's recommendation.
I'll second.
Thank you. We have a motion by Judge Kane and a second by Judge Nelson on case number 4 to accept legal counsel's recommendation by roll call vote. Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson.
Aye.
Thank you. And Michael Wright.
Aye.
Thank you. Mike, number 5, please.
And finally, we have case number 5, since we've already taken case number 6 out of order. This complaint states and/or restates the following. We have 7 allegations. Number 1, the county is not receiving the court costs and fine money because the respondent is not doing their job correctly. That has just been addressed. Number 2, financial reports are supposed to be filed each quarter to the court clerk, and the respondent has gone 5 years without filing probation reports. The respondent late filed the 5 years of quarterly reports on December 9th of 2022. The council has already addressed that allegation. Number 3, the complainant believes the reports are not accurate and the numbers are just made up. Number 4, the respondent is not keeping a log when he meets with people on supervised probation. Number 5, the respondent is using persons on misdemeanor probation to do work on the respondent's personal property, naming a specific individual. Number 6, the respondent does not perform drug testing. And number 7, the respondent will not violate a person's misdemeanor probation if someone is arrested. Just kind of taking these allegations in order. Number 1 and 2, we've already discussed. Number 3, complainant believes that the reports are not accurate and the numbers are made up. We don't have any evidence to back that up. Furthermore, that is not covered by a statute or a specific reg giving us explicit authority to investigate such a complaint. Number 4, the respondent is not keeping a log when he meets with the people on supervised probation. Looking at regulation 1177-01-005, what is to be provided is the number of contact hours with offenders. While I personally believe that, keeping a log would be a good practice point, I do not see that explicitly mandated. That has to be produced with a quarterly report. Number 5, respondent is using persons on misdemeanor probation to do work on the respondent's personal property. I tried to contact the individual listed since we had his file previously, and I was not able to successfully get in contact with that individual. Number 6, the respondent does not perform drug testing. Again, there's not an explicit statute or regulation to cover that. However, in the files that I found, that was covered in the order between the court and the probationer, and that it was discretionary, specifically stating may and not shall. And number 7, the respondent will not violate a person's misdemeanor probation if someone is arrested. Again, that was covered between an order between the court and the probationer. And again, that is discretionary, stating may and not shall. So with regard to item number 5, the vote and the recommendation would be closure. Again, we are already sending out a letter of warning regarding the timely filing of the quarterly reports with the clerk.
When you said you could not get in contact with the person, you talking about the person filing the complaint or the person that's being complained upon?
The person alleged to be performing personal work for the respondent.
Okay.
I'd
I would
move we
move
would
to
follow
accept the-
recommendation.
I would second that.
I believe we have a motion by Judge Kane and a second by Judge Perry, if that is correct. And this is on our last case, which is number 5, to agree with council's recommendation by roll call vote. Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson,
Aye.
Michael Wright,
Aye.
all in agreement. That concludes our legal report with all 6 cases. Michael Underhill, I don't know if you have anything else or our council has anything else regarding the legal report. I don't have anything on new business, but I want to take a moment to give everybody a chance here before we move on.
Roxanne, I have nothing further.
Thank you, Mike. Council members, I have nothing under new business. If you all do, happy to entertain that. If not, we would take a motion to adjourn and conclude our meeting.
I'll make the motion.
Thank you, Judge Perry. If a motion to adjourn, and I have us ending at 10:35. Do we have a second?
I'll second it.
Thank you, Judge Hudson. By roll call vote to adjourn our meeting, Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson,
Aye.
Michael Wright.
Aye.
Thank you, everyone. We are adjourned, and I hope everyone has a wonderful rest of your day and weekend. Thank you for all you do.
Thank you.
Thank you.
Have a
Bye-bye.
good
Thank you all. You too.